I'm attorney Neil Colmenares with VegasDebtRelief.com. I've created this video to give you some basic information on how to discharge student loans in bankruptcy. Here are some common questions about discharging student loans in bankruptcy. First, can I file bankruptcy on my student loans? The answer is yes. Are private student loans dischargeable in bankruptcy? Again, the answer is yes. Finally, are federal student loans dischargeable in bankruptcy? The answer, once again, is yes. While it is true that student loans are not automatically discharged in bankruptcy, like everything in the law, you must first find which rules apply and then look for exceptions. Here is the process to discharge private and federal student loans in bankruptcy. First, make sure it is a dischargeable student loan for bankruptcy purposes. The Bankruptcy Code has a very specific definition of what a student loan is. If your loan does not meet this exact definition, it will be discharged as part of your bankruptcy despite the bank saying you cannot. In plain English, an example of a dischargeable student loan is a loan given in excess of the cost of education. This means each school determines how much it will cost for you to attend each semester. If your student loan exceeded that amount and you use part of the student loan for other than what the school said you should use it for, by using the bankruptcy definition, it is not a student loan and should be discharged in bankruptcy. See the corresponding web page on this website for more examples of dischargeable student loans. Next, assuming your loan meets the bankruptcy definition of what a student loan is, it can still be discharged if the undue hardship test is satisfied. In plain English, the undue hardship test states your student loan should be discharged in bankruptcy if repaying the student loan would impose an undue hardship. Although difficult, passing the undue hardship test is not impossible. Here are the requirements. First, based on current income and expenses, you and your dependents cannot maintain a minimal standard of living if forced to repay the loans. Next, there are indications that your state of affairs will likely persist for a significant portion of the repayment period. And finally, you made a good faith effort to repay the loans. If you are interested in a student loan bankruptcy consultation to see if you can discharge your federal and/or private student loans in bankruptcy, you will need to gather a few documents. First, a letter stating your cost of attendance, approval and denial letters, proof of loan disbursements, medical diagnosis, recent student loan statements, etc. See the corresponding web page on this website for a detailed explanation of how to obtain each of these documents. Once you have these documents, take the next step by contacting us for your free student loan dischargeability consultation. I'm attorney Neil Colmenares. I hope you found this information useful.